Okay, so welcome to our third session. Just a minute. I hope PPT is visible to everyone. Sorry, not PPT, this Word file. Kindly confirm me in the chat or kindly unmute yourself and you confirm me. Okay, thank you. So let us start with cause list. Now, as we know, briefly, those who do not know what is cause list. So, cause list is a list of all those cases which are going to be heard on that particular day. Usually, it is prepared on the previous day. In any court, it is prepared on previous day. And in case of high courts, it is listed on the website also on the previous day. So let us see the rule 38. It speaks about the preparation of cause list. Then it says that it shall be prepared for the next working day. That means it will be prepared on the previous day. Now, in case of tribunal, usually you will get, even in high courts, you usually get an intimation of the next date of your case or the first date of your case. So you make it a plan, you mark it in your calendar that my case is going to be listed on this particular date. But it is a likely date, it is a probable date. On the previous day, you will come to know whether your case is listed or not. Now, when it comes to cause list, now as of now, a main difference between SISTAT practice and High Court practice is that in case of SISTAT, you come to know in advance that your case is likely to be listed and it gets listed. And SISTAT, normally the cases which are listed are heard on that particular day. Uh, there are very less unheard cases, but in case of High Court, they will list 100 or 110, 120 cases, but some benches they finish like 15 cases, 10 cases, 20 cases, 30 cases. Some benches are fast, some benches are slow. And very often your case is it does not come up for hearing. And then it gets goes on getting postponed. So that is a big problem. So in case of GSTAT, what will happen that we don't know because initially there will be huge pendency. Now, here, Rule 38 Subrule 2 says that cause list will contain the categories under which the cases are listed. Like, for example, cases for pronouncement of orders. So, here both hearings are completed, and this case there is no argument, only the tribunal will pronounce the order. Cases for clarification, some only clarification is sought, so it is listed only for clarification. Cases for admission, as we saw yesterday, in some cases where there are some defects raised, then the registrar has listed the case for admission hearing. So the bench will ask the appellant, and the bench will decide whether to add. This admission hearing will not take place in every case, only in certain cases. Cases for directions. Now, what is this? For example, if an appellant wants to give some evidence in an appeal, he has already filed an appeal, he wants to give some evidence, and that particular document he is asking from the jurisdictional officer, and the jurisdictional officer is not responding to his letters. Now, in this case, the appellant can apply to tribunal to direct this respondent to give that document to him. So this case is listed for order for direction. So there could be several such directions. I just given one example. Then come the part heard cases where hearing continues. So here they give the precedence will be given to the latest heard cases so that continuity is maintained. And these cases will be posted as per numerical order. Registrar will communicate the date of hearing to the parties. So we will come to know in advance that our case is likely to be listed on this particular date. But whether it is listed or not and at what serial number it is listed, that we will come to know only on the previous day when the cause list is prepared. All details like in the daily cause list, the number of appeal date, sitting bench, courtroom number. So all those details will be mentioned. The names of legal practitioners or authorized representative will be mentioned. So names of parties will be mentioned. If tribunal does not sit on a particular day, then a new cause list will be prepared. Your case will get postponed to next date. Now, I'll show you an example of a cause list. Just a minute. Now, this is a cause list of Bombay High Court on a particular date. See, here Bombay High Court. So here it will come GSTAT, so and so bench, daily cause list for this date, court number 6. So here it will be hall number 6, right? Now, these are timings. These are the names of the judges. So in this case, it will be judicial and technical member. And then here are the categories. So here in Bombay High Court, certain cases are taken at a fixed time, 2:30 p.m. These two cases will be taken. Then for regular 10:30, now this is for compliance. So these cases, two cases are listed for compliance. For amendment. Now this one case is listed for amendment. So when you want to make an amendment in your appeal or writ petition, then it is listed for amendment. Then first on board for direction, as we discussed, for ad interim relief. So like that, there will be different categories. And if you see here, it is serial number, then appeal number or case number, then name of the parties, and then who is the authorized representative, advocate. So all these things will be there in the cause list. So this was an example of cause list. Now let us go again to the rules. Just a minute. Okay. Now let us come to rule number 40, which is about service of notices and communication. So as we know, section 169 of the CGST Act specifies various modes of service of notices and other communications, like uploading on the portal, sending to registered email ID, or sending by post, and any one of the modes is valid. So here the sub rule, this rule says that the service will be in the same manner as specified in section 169, except that for GSTN portal, it will be GSTAT portal, right? Again, sub-rule 2 empowers the tribunal that in particular case, if other modes of service are not practicable or they fail, then the tribunal may allow the other modes of service or even substituted service. That is, in place of the particular person, it will be given to some other person, like some other adult family member in his family, like that. So that power is given, that facility has been provided for. And also sub-rule 3 provides that if the letter of authority has been given in favor of a professional, then service to that authorized representative can also be made and it will be deemed to be proper service. Now come to chapter 5, hearing of appeal. Now rule 41, the hearing will be held on the specific day. Now sub-rule 2, here it is interestingly it says the tribunal will first hear the appellant, and subrule 2 says if necessary then he will hear, the bench will hear the respondent. Now why the words if necessary are used? Because see, hearing is a necessary, it is a must for following the principles of natural justice. But why is it said if necessary? Because certain cases may be such, like for example, if the appellant is withdrawing the appeal, or if the issue is squarely covered by a precedent. So in those cases, the hearing may not be hearing of the respondent may not be necessary. But again, this will be subject to the principles of natural justice. The opposite party can always raise this ground in the higher appeal. So tribunal will definitely exercise this power very judiciously, but the power has been kept. Now this is very important. Rule 42. So, what does this rule say? Now, this is somewhat unjust, and actually, in my view, it is ultra vires the act also. And previously there has been a case law on this. Now, what does this rule say? If an appellant fails to appear on the date of hearing, then the tribunal has the power to reject the appeal on the ground of default, on the ground of non-appearance. The tribunal has that option. Tribunal can reject, or tribunal can decide on merits also. But ideally, it should not be so. Ideally, the tribunal should decide on merits, because the appellant has submitted the appeal, he has given all the evidence, appeal is admitted. Only because he fails to appear, the tribunal shouldn't have the power to reject the appeal. And this power is not expressly given in the act. So, whether this rule is right or not, time will tell. But previously, there has been a case law. Again, if the proviso says, if the appellant did not appear, but he can subsequently appear, he can make an application for restoration of the appeal, and the tribunal can restore the appeal. This is rule 42. 43. Hearing of appeals ex parte. Now, if the respondent does not appear, then the tribunal can hear the appeal ex parte and decide it on the merits. Then, now continuance of proceedings after death or disqualification, like adjudication as insolvent of a party to the appeal. If the appellant or respondent, they become disqualified because of insolvency, or if they die, then the by default the appeal abates. But the party can make an application, the successor can make an application for the continuance, and that application normally should be made within 60 days, but the tribunal can extend. Plus, as we saw yesterday, rule 13 14, they also empower the tribunal to extend this time. Now, this is also an important rule 45, production of additional evidence. So, during the in the course of the progress of the case, right from adjudication level to tribunal level, you have adduced some evidence. Now, normally, any additional evidence cannot be adduced, right? But in cases where the tribunal is satisfied that you were previously not in possession of that evidence, or the adjudicating or first appellate authority did not give you sufficient opportunity to produce that evidence. So in such cases, tribunal can allow additional evidence. Then the tribunal, subrule 2, the tribunal is also given the authority to appoint some authority who will take evidence, right? So this is done to save the time. So tribunal may say that this particular procedure, you want to submit this evidence, like you want to submit ledgers, confirmations, this, that, a number of things. So you submit them before your jurisdictional superintendent, and then let him comply with that and let him submit his report to us, so that the time of the tribunal is saved. So this power is given to the tribunal by subrule 2 and 3. So the authority to whom such a direction is given will comply, and it will submit its report. So that is about documentary evidence. Then the tribunal, subrule 4, the tribunal can also on its own call for any documents or summon any person for witness. Then 46. Now this is about production of evidence by affidavit. Although it is not explicitly mentioned here, this is testimony. Evidence here, see, evidence can be both. It can be documentary evidence, or it can be oral evidence. That is testimony. So 45 speaks about documentary, although it is not expressly mentioned, and this speaks about the testimony. So normally, subrule 1 says that whenever tribunal wants any evidence in the form of testimony, somebody is coming and standing as a witness and giving his statement, so it can be given alternately as affidavit. So that person need not come before tribunal. This is to save time of all. So he can give it as an affidavit. So that is what can be done. Plus, subrule 2 says that if necessary, like for example, cross examination is required. If appellant requires that, while passing order in my case, the adjudicating authority had relied heavily upon the report of a particular GST officer, I want to cross examine. Now, if this affidavit is not enough for me. Or for example, let us take another case where the department has taken stand that we had served a notice, show cause notice, but the assessee says that I have not received the notice. Now, departmental officer, he has given an affidavit that I have served the notice, but the assessee wants to cross-examine. If you served, then where is the acknowledgement? If there was COVID, then how did you serve? So then in such case, sub-rule 2 provides that the tribunal can direct such cross-examination through video conferencing. So that will save some time also. Then 47, appeal can be adjourned if the tribunal thinks fit for any reason, it can adjourn the appeal. Now, Rule 48, the proceedings will be open to public. Now, those who are interested in practicing before GSTAT, I would suggest what they can do whenever possible, they can just go and randomly sit in the uh, it is typically called court, although it is not technically court, but here also you will find the word court diary everywhere. So loosely we can call it a court. So you can randomly go and sit there just to observe the proceeding, how it happens, how the counsel addresses the judges, addresses the opposite counsel, what are the typical procedural things, what are the typical words used, like honorable bench or your lordship, whatever. So all these things you can observe. So this will be open to public except where the tribunal thinks fit that this should not be made available to some, to all public or to some section of people. Then it can impose such restrictions. This is similar to what we find in CPC. CPC also the same thing is there. Court proceedings are open to everyone and the court has the power to restrict. Then 49 says all these procedures will mutatis mutandis apply to interlocutory application also. Rule 40, appeals can be referred to larger bench. Like for example, suppose if the tax involved is less than 50 lakhs, it is being handled by single bench. So it can refer it to a larger bench if substantial question is involved. So it can refer. Now, Rule 51 speaks about how the orders are to be signed and what should be the date of the order, like in various scenarios. Now, this is purely technical. For example, if the order is dictated on the bench, sometimes what happens after the hearings are completed, then the bench dictates the order to the steno immediately on the spot. In such case, the date of dictation is deemed to be the date of the order. So, although the order will come later in typewritten and signed form, it will come later. But the order's date is deemed to be the date of dictation. Now, when it comes to time limit for, say, filing an appeal before High Court, the time limit does not run from the date of the order. Time limit runs from the date on which you receive a copy of it, right? But uh, this date of order so dictated, then if the order is reserved, then sometimes bench what the bench does, we are reserving, and like next week they will list it in the cause list for pronouncement of the order. In such case, the date of final order will be the date, or sometimes gist of decision is pronounced. Okay, so in principle we allow this and we don't allow this, and then detailed order follows. Then the date on which the members sign that order, that will be the date of the order. So this is purely technical. Now orders can be published, as may be necessary. Then come to chapter 6, which is about a record of the proceedings. So here, court diary, the registrar shall maintain all the court diary, and then there will be main in so coming rules. We are going to see what type of files will be there. So main file, process file, and four types of files will be there. So he will maintain all the history of the appeal, substance of the order, everything. Then order sheet. Now, what is order sheet? So during the progress of the appeal, several orders are passed. Like for example, admission order is passed, or some direction orders are passed, or interlocutory orders are passed, or even adjournment orders are passed, or uh, if the serial number doesn't reach on a particular day, then it automatically gets adjourned. So that adjournment order is passed. So like that. So all those orders will be noted in this particular order sheet by the registrar. Now he will maintain, the court officer will maintain the court diary, and in the court diary every day's proceedings will be recorded. What cases were heard, what was the status. Like for example, this case was heard for say a particular purpose, direction. The court directed this. This case was listed for admission, so the court admitted this. So this case was listed for argument, the argument was half done, and next date given is so and so. So all these things will be noted in the court diary. Now rule 56, the statutes or citations for reference. Now this is a provision has been made. I'll tell you what happens practically and what is the provision made. So whenever we are filing any appeal, we are quoting so many case laws. So what does this rule say? So whatever acts, statutes you are relying upon, by and large, we will rely upon CGST Act, IGST Act, and relevant rules and notifications. But sometimes we may have to rely on some other statutes also. So we have to give those copies of those statutes beforehand. And whenever we are relying upon case laws, we have to give those case laws, full text of these judgments beforehand. So before the hearing starts, in the early morning, we give that. Practically, how it is done? Practically, it is not done like that. Practically, there are two bunches of paper in our hand. Now, one is called paper book. A paper book is your appeal, so it is duly numbered index, so that is available with the bench also and with you also. And second thing, popularly in court terminology, it is called as compilation. So all those case laws which you are relying upon, they are bound or they are stapled like, and they are, you can do the page numbering also, and you give a compilation to the judge and you have in your hand, so that whenever, see, in the appeal, we are quoting the relevant portions from the judgment, but only relevant portions. The entire judgment is not there. Sometimes it is necessary. Sometimes the opposite counsel may argue that certain paras you are not quoting, those are in favor of the department. So then it is necessary to have entire judgment. So a page numbered compilation is prepared. It is given to the opposite counsel. It is given to the judges also, and one is in our hand. So it becomes easy. At page number 78, this court at para number so and so observes this. I will read this. With your permission, kindly permit. Can I have the permission to read this? So like that. So these things should be given. So this is rule 56. Then calling of cases in the court. So the spune will call this, and as per serial order, the cases will be called. Now, regulation of court work, the registrar will ensure that there is no wastage of time, silence is maintained, dignity and decorum is maintained, no mobile phone should ring. So then there will be huge penalties if it does. Then court officers' duty is to ensure that all proceedings are transmitted to the registrar, because registrar is doing all those things of preparing next cause list or giving you the intimations of the case status. So court officers' duty is to do that. Now let us come to next chapter, maintenance of registers. Now various registers are to be maintained. Now here see three types of registers. Firstly, it is GSTAT CDR3. CDR for stands for code diaries. 3, 4, and 5. 3 is for unnumbered appeals. Then 4 is for appeals. And 5 is for interlocutory applications. Now, 3 is for when you submit an appeal, as we discussed, then it is not immediately admitted, number is not given. It is provisional, it is subject to scrutiny, then removal of defects and all those things. So when appeals are filed, they will go to this CDR3. And then when the number is granted, then they will go to CDR4 until they are fully disposed. And CDR5 will be the register of interlocutory. Now this is for their internal thing. So we are not much concerned about that except for the appeal number. Then arrangement of records in pending matters. So as I said, there will be four files. One is main file. So contents of main file, it is your petition or appeal. So it's index, order sheet, final judgment, appeal, counter reply, evidences, oral documentary evidences, arguments. So these are the main things which will be there in the main file. Then second is the process file. So procedural things like wakalatnama, letter of authority, then summons for the affidavits, applications for summoning witnesses. So this will be in the process file. And execution file. Now execution file may not be necessary in every case. What is execution file? If the tribunal has passed any order and the other party complies with it, then there will be nothing in the execution file, because execution file will come into play if the other party does not comply with the order. In such case, the party in whose favor the order is given, it will apply to the tribunal for execution order, and then those things will be there in the execution file. So these will be the court diary files. Then file for miscellaneous applications. There could be any miscellaneous applications. Then preservation of records. Now, main documents, there will be two things. One is main petition or main application. So sub-rule 2 says that it will be preserved for 15 years, and supporting documents, relied upon documents and records, they should be preserved for 5 years from the date of final order. So now these things will be clubbed together. So mostly these will not be separated. Everything will be kept for 15 years, mostly in every likelihood. Now, uh, this is again very technical, not of much importance to us. Retention, preservation, and destruction of records. Now come to inspection part. Now in case of inspection, section rule 67 allows the inspection. Now here it is interesting to note that the word used here is applicant. Now applicant can apply for inspection, but here it does not say that party or appellant or respondent. So it seems that any person who is not even related to the case can apply for inspection. Right. Now again, inspection is subject to the uh, permission by the registrar. So it's not that I want to inspect, so I will go and I will inspect. Not like that. It is subject. But here, interestingly, they use the word the applicant to any case. Right. The applicant to any case or authorized representative, he may apply, then he will pay the fees, rupees 5 per page, something like that. It is given in the schedule of fees. And then the registrar will grant only on the order of the registrar, Rule 68 says. So registrar will grant the permission and then only you can inspect. So application is to be presented to the registry. Then registry will put that application before the registrar and he will pass the order and then you can inspect. Now there is mode of inspection. The timings are given for inspection and it is to be done in the presence of the officer of the registrar. Then you should not make any marking on it, right? Then there should not be any damage to the documents. So all these things are given here. Then register of inspection has to be maintained by the registrar. So this is about inspection. Interesting thing what I find here is that there is no condition that only related persons can do this. Then, okay, we will stop here and we will take any questions if there are any questions. And tomorrow, this is very interesting part. Authorized representative. I have certain observations and comments in this regard. So, anyone has any comments or questions? Okay. If you have any questions or comments, you can unmute and you can ask. Okay, fine. So, there is no question and no comment. So, we will meet tomorrow and we will take it further. Thank you very much. So, I'm ending the meeting.